Our fourth and final panel involves neurological medicine and the medical legal process from the perspective of defendant, applicant, and the reporting physician. This panel was to include Dr. Frederick Newton, Brian Egan, and Mark Gerhardt. However, apparently due to Mr. Brian Egan's age and other COVID-19 risk factors, he was prevented from presenting. Therefore, Mr. Michael Giacchino graciously agreed to step in, with Mr. Richard Montalbo acting as the panel's moderator. Again, this panel will include presentations from the Vizcaya Ballroom and remotely from various locations throughout the state of California. Dr. Frederick Newton will be presenting live remotely from his Bay Area home. Dr. Frederick Newton is a true icon in the field of California workers' compensation law and medical legal evaluation, having reported exclusively as an AME for well over 5 decades. He is respected by both the applicant and defense bar and is known as the Dean of Medical Legal Evaluations. Dr. Newton is the namesake of the Newton Medical Group, the AME group of reporting physicians within ExamWorks IME services. Dr. Newton is a graduate of the University of Rochester School of Medicine and completed his residency at the University of California, San Diego. Dr. Newton is board certified by the American Board of Electrodiagnostic Medicine and the American Board of Neurology and Psychiatry. From 1973 to 75, Dr. Newton was the Chief of Neurology at the Letterman Army Medical Center, Presidio of San Francisco, and has held a number of other positions at various other medical facilities, including Mount Zion Medical Center. Dr. Newton will be joined by Mr. Giacchino, who has traveled to the Vizcaya to present. Mr. Giacchino is a graduate of the University of California, Berkeley, and the San Francisco Law School. Mr. Giacchino joined the firm Hannah Brophy in 1985, becoming a partner of that firm in 1989. He is currently a senior partner and managing partner for the H&B Oakland office. Rounding out this panel is one of the truly great legal scholars in the field of workers' compensation law, Mr. Mark Gerhardt. Mr. Gerhardt will be presenting live remotely via audio feed from his Bay Area home. Mr. Gerhardt is a graduate of the University of California, Hastings School of Law. He is an annual speaker at the California Applicants Association conferences. Mr. Gerhardt is a noted expert on presenting VR evidence pursuant to the Ogilvy-LaBeouf doctrines. He is currently on the board of directors of the California Applicant Attorneys Association and also co-chair of the CAAA Regulations Committee. He is also responsible for a number of seminal appellate court decisions in the field of workers' compensation law. Our final panel is already underway.
Well, we're winding down here. We're in the last session of today's, and so far nobody that's tuned in to see a wreck has seen one. I think we're going to make it through. This last panel is going to be interesting. I've asked Mike Giacchino to join us, and I'll be kibiting on this. It's neurology in the medical legal process, and the way that we set this up was to be a topical discussion with a number of topics that we're just going to banter around and comment on. This is a great opportunity for me personally to ask Dr. Newton some questions and see what his thoughts are on some. But let me introduce everyone on this panel. Of course, we've already met Mike, and some of you have met me, but we have 2 additional panel members that certainly are at the top of their profession. We have Mr. Mark Gerhardt. Mark is appearing by phone and audio only. And Mark is, as I indicated, he's active in the California Applicants Attorneys Association. He's been on the, I believe the amicus brief, but I know the education, the ed committee, and he's an active presenter not only at my conference, he's spoken a couple of different occasions here, but also statewide and especially with CAW. Mark is an applicant attorney in the Oakland, primarily in the Bay Area, but the Oakland board. Mark is responsible in large part for a lot of the development in case law associated with, well, generally, but specifically Ogilvy. We're also joined by Dr. Newton. As I indicated this morning, this is my opinion. Dr. Newton is the platinum forensic evaluator, QME, AME. He doesn't do QMEs, but he's only an AME. He's a doctor that, and this is how I would describe Dr. Newton, he's a physician that I go to on the most complicated cases, knowing that he is going to explain it to me, especially when I'm lost in the forest and I'm not sure what the answer is. He's somebody who I trust. Every time I take his deposition, he's always prepared on that file and always knowledgeable on the law. I didn't know this, but he was the past president of the California Society of Industrial Medicine and Surgery. I didn't realize that. He's also, of course, the founder of Newton Medical Group, which is, as I understand, the only medical group in the state of California that's made up of exclusively AME doctors that accept only AME referrals. Okay, let's go ahead and begin the discussion here. The way that I wanted to start this discussion was to first discuss the use of AMEs versus QMEs. And I wanted to start this discussion with asking, first of all, Mark Gearhart. Mark, are you there?
Yes, I'm here. Can you hear me?
Yes. Mark.
Hello? Can you? Okay.
Yeah,
good.
We can hear you. Mark, can you give us your insight on the use of agreed medical examiners versus PQMEs, and what your thoughts are on whether or not we should be using one or the other, or are there circumstances that you find the use of one more important than the other?
Well, I'd be happy to, and thank you, by the way, for that not very nice introduction. AMEs and QMEs, my thoughts on this have really changed over time. I've been doing this, practicing workers' comp law on the applicant side for 39, 40 years, and 20 years ago, I didn't use AMEs much. I went to my own QME, the defendants got their QME, that all worked out pretty well most of the time. And I'd use AMEs once in a while if you had a really complicated case, or the applicant and the defense doctor were so far apart you couldn't figure out what to do to settle it. But with the advent of the panel QME system, I gradually changed, and I use AMEs quite a bit now, and there's a reason for that. I've noticed with the panel QME system, and I have to say there's some excellent panel QMEs, so I'm not trying to say everybody that's a panel QME does a bad job, but there's a lot of panel QMEs who frankly don't do a very good job. And I've asked myself, why is this? And I think there's some perverse economic incentives built into the panel QME system. Economically, if you want to maximize your income, what you do is you have to have 10 satellite offices. That's the most you can have. Before they limited it to 10, some of these people had more. You have 10 satellites. You fly in, you see a whole bunch of patients in one day, and you crank out a whole bunch of reports, none of which you spend a whole lot of time on. And they're sort of mediocre at best. And, you know, if they don't answer all the questions, or they get the law wrong, or they get the history wrong, hey, you know what? You get asked for a supplemental report, or you get to post, and you get to bill again. So what the heck? And I think that's led to a declining quality, average at least quality, on the QME reports. We also have a declining number of QMEs, and that's been documented by the state. It's been going down ever since they passed the panel QME system. And at least in the Bay Area, we have cases where, you know, you'll go through 2-3 panels before you get to a doctor that, you know, can see the patient within the time frame, and either side, you know, either side goes along with them because they use their strike. And we've had cases where we're on panel 4 and 5. We've even been reduced to petitioning the board to appoint a regular physician to try and move the case. Mm-hmm. So I've become really frustrated with the system. I don't think it works well, and I think the way it's designed, it can't work well. And all these panel disputes and delays, you know, obviously slow down case resolution, increase frictional costs, et cetera. So I've started to use AMEs a lot more. You have to wait a longer time. You know, a lot of the good AMEs you may wait 6 months or more to get into, but if you make the agreement early in the case, I think it works out pretty well in a large number of cases, because really what we all want is a rational report that covers all the medical records, the history, the complaints, thorough physical exam, reasonable conclusions, so you can resolve the case. I mean, that's what mostly we're all looking for. And I think your odds of that are probably higher with a good AME. Right. So I've started to use them quite a bit more.
I agree with that. Before I turn to the doctor, I'm going to ask the doctor in a minute some questions about how you become an AME and what advice he would be giving younger doctors who want to be involved in QMEs. But before I do that, I want to ask Mike if he's had some of the same experiences with getting authorization to utilize an AME in a particular case from his clients. Mike, do you have any problems with that sort of thing?
It is a matter that is becoming more common where the client is willing to go to the panel. I find this a lot more. I go to Southern California, and the Southern California practice seems to be much more geared to panel utilization. It might be because of the fund of physicians that are down there, a lot of chiropractors, a lot of non-neurological, non-orthopedic examiners. So I've got clients that live and die by the QME. And the pool of AME types for us, and I have been in the business as long as Mark, is shrinking. It's shrinking, it's deathly shrinking, literally, to the point where it's finding even the acceptable AMEs to be acceptably able to get into them. So the short answer is yes. We've got clients that seem to be pretty satisfied with QME world, as dissatisfying as it can be in the litigation arena. And I agree with Mark about the push-pull of the quality of QMEs that we're starting to see. Will often an attorney like Mark will take a deposition of a QME, and quite frankly, it's a bloodbath, literally, that unfolds before your very eyes. And this didn't used to be the case when we had a fund of QME types before the panels, and when we had a very large, at one time, 15 years ago, there was a group of AMEs that were pages and pages. That doesn't exist anymore for a lot of reasons.
Well, I'm not going to ask Dr. Newton. I'm not going to put Dr. Newton on the spot, but I am going to make a comment. My clients have never once over the last 5 years come to me and said, Richard, this doctor's charging too much. This is not pursuant to the ML schedule. We're not going to pay this. I just don't hear it. And yet the state has decided, for whatever reason, to take action. And I know I'm climbing out on a limb on this, but I absolutely am adamant about this. I don't know what certain bureaucrats within the state system thought that they were going to accomplish. And I'm going to leave it at that, and I'm going to end that with a question to Dr. Newton. Dr. Newton, from my vantage, I'll just tell you, nobody, when I'm down at the board and I have an issue involving neurology, even orthopedic surgery, you are a go-to guy, and that doesn't mean that we don't have an orthopedist who also reports on it, but and everybody agrees to you. So here's my question. What is it that you're doing, besides your experience and knowledge and all the years that you've done it, what is it that you're doing that you think you'd want to share with doctors that may be watching this to get to that level where everybody is acceptably dissatisfied? No, I don't mean to say that, but acceptably satisfied with your opinions and how you do your work. So what makes an AME, and how does just a standard QME get to become an AME?
Can you hear me?
We can.
Yes.
Okay, well, first of all, I just want to thank you for your nice comments on the introduction. I appreciate that. Well, that's a interesting question. You want me to give all that away for free?
Yes.
Well, give away as much as you feel comfortable giving away. Because it's not only you, it's your entire group. When I want to go to an AME, there's a number of doctors within your group that I'll use.
Sure. Your question takes me back, if I can share the story, to when I first started out doing evaluations, and my experience goes back as far as the other panelists, 35 years of reporting in the workers' compensation system. And I was getting referrals from orthopedists at the time, and that's how my name became known to insurance carriers. And I started getting requests to do evaluations. I went to speak with an orthopedist who at the time was widely recognized as probably the premier physician in performing evaluations in the state of California. He's gone now, but his name was Dr. Joseph Bernstein. Some of you may remember him.
Certainly.
Not only was he a superb physician and an excellent evaluator, but he also delighted in serving coffee and donuts at his depositions. So I went to Dr. Bernstein and I said, you know, I want to perform evaluations. I see this as an interesting aspect for my career. I think I have an analytical mind. I think I write well, but I don't know how to get started. And Dr. Bernstein said to me, well, the first question that I would ask you is, do you want to be an applicant doctor or a defense doctor? And I thought about that for a minute, and I said, well, I don't really want to be either. I want to be a good doctor and not take either side. And Joe Bernstein said, well, that's the right answer. We can continue on with our interview. And it really started from then, the idea of reporting without regard to the letterhead. And what that meant was that early on, there were fewer referrals, because if you identified yourself as a conservative or defense-oriented clinician, you immediately started getting referrals from the defense side. This was, of course, before the panel system. And if you identified as a more liberal-leaning physician, then you started getting referrals from the applicant side. And it was slow going at first, but it was building. It was building with a long lens approach, and it served me well. And so I've incorporated that into my teaching through the years to clinicians who want to become AMEs, that they have to recognize that their reports should be the same, irrespective of who is referring to them. I think that's one of the biggest differences, actually, between the QME reporting and the AME reporting. We just heard about the problems with QMEs. And indeed, there are many problems, and I hear about them all the time. I see them all the time. Mention was made of a perverse economic outlook. I think QMEs and AMEs have a fundamentally different approach, even though they're answering the same questions. Well, maybe not answering the same questions, because I think AMEs tend to make sure to answer every question that they're asked. Yeah. QMEs often don't. I always instruct clinicians to make sure you answer every question you're asked, but also make sure not to answer questions that you're not asked. And that's an important distinction. An AME is really writing a report with an eye on his or her next referral, whereas that's not true for a QME. So what do I mean by that? A QME is chosen blindly. It's a random assignment by a computer. An AME, and I say that recognizing that there are strikes and so forth, but nevertheless, it's fundamentally a random system. And QMEs try to capitalize on it by having as many offices as they can, as was stated earlier. AMEs are chosen by the parties. So there's a fundamental difference.
Well, Doctor, can you give us some, I'd like to listen to some thoughts on how you personally handle the difference between subjective findings and objective findings, and how you balance that as an AME, and what considerations you give to each. How does that work when you're doing, after you've done an examination and preparing a report? What do you rely on? What do you look to? Or are they dependent one on the other?
Well, they're interrelated. And to use a word that's thrown about a lot, they're synergistic. But I think the AME approaches the report writing in terms of both subjectives and objectives differently than does the QME. It's not uncommon in my experience for QMEs to undertake multiple reevaluations. And oftentimes, because perhaps, and I don't want to smear QMEs. I mean, some of my good friends and colleagues are QMEs and do an excellent job. But I'm talking about the problems and the issues that the system is well aware of. Some QMEs, if they report infrequently, will have a tendency to find that the person not at maximal medical improvement. And I'm sure you've all seen evaluation after evaluation after evaluation and reevaluation before the case is brought to conclusion. An AME recognizes that his or her job is to help bring the claim to resolution promptly. That's part of why the parties are coming to us. So we make every effort to find the patient at maximal medical improvement if the medicine justifies that. That's a fundamental difference in reporting. Insofar as subjectives and objectives are concerned, I think AMEs have to carefully assess subjectives and understand that there's a need to look for support in an objective sense. In other words, I think AMEs are less likely to take the subjective report of the patient at face value. Mm-hmm. Rather, they will look carefully at everything in the record. If a given complaint is offered by the patient as a subjective, an AME will tend to be more analytical and look back and say, when did this complaint occur? When did it enter the record? How is this patient who is being sent for vestibular therapy for dizziness for their head injury undergoing this treatment when they didn't have dizziness for the first year after their injury, for example?
Well, you know, Doctor, I remember taking your deposition. I was a young attorney and probably stuttered a lot. And I showed up, and the applicant attorney, during his presentation, he really wanted to have the subjectives. And I remember you coming through and saying, I use the objectives to support my conclusions regarding, or I use the objectives to support my conclusions and my findings regarding subjectives. In other words, you look to the objectives to validate the subjectives. And I thought to myself when you said that, wow, I wish more doctors understood that sequence. Is that pretty much what you're conveying here?
Yeah, exactly.
I want to ask Mark.
Can I just interject something, Rich? This
Sure.
is Mark Gerhardt.
Sure.
I think that's all excellent, and that's what I'm going to want the doctor to do too. There are some physicians, however, I just want to point this out, who kind of discount or ignore subjectives because they're not objective, and I think that's something that's not valid, because if you're practicing medicine, you're treating the patient or evaluating the patient, and you're not doing that in a vacuum, and the subjectives have to be considered. But I just want to comment, I totally agree that you don't take them at face value, but you also don't ignore them. They're part of the whole picture.
If I can respond, I think that's an excellent point, Mark, because after all, there are a number of conditions which are exclusively subjective in nature. There are no objectives.
And that doesn't mean they don't exist.
No, precisely. I mean, there are no objectives for the most part in any head injury case with headache. There may be objectives in regards to dizziness. A neurootologic examination may show certain physical examination findings that we look for, but they're not necessary to support the diagnosis. So there are numbness and tingling is another example. There may or may not be objectives to support it. So what's a good clinician to do? Well, certainly not throw out any symptom for which there are no objective supporting findings, for the very reason I just stated. But if there are no objectives, how does that patient get evaluated reasonably? And that's where an analytic approach and a careful, methodical review of the medical records is mandatory. That's where the validity, if you will, of the subjectives becomes better established. Is there a consistent thread of symptoms? The symptoms typical? What other symptoms accompany the physical findings? How are they presented by the patient? Are there pain behaviors? Is there some indication of exaggeration, of symptom amplification, of common phenomena that we see? So at the end of this, it's important to recognize that it's nice when you have objective findings to support subjectives, but you don't necessarily need them.
Okay, I want to move along here. I'm going to throw this to Mark for a quick answer, then I want to go to Mike on this, and then I want to come back to the doctor to see, with everything that's going on in the state of California, well, throughout the country right now with COVID-19, I'm wondering if telemedicine, an examination telemedicine-wise, is an option, or if we on the defense and the applicant, on the applicant side, counsel for applicant, are going to have any objections. First of all, Mark, what are your thoughts on that?
Well, I think that's a great question, and the answer is kind of it depends. The good point about that, obviously, is it avoids exposure to the virus. It also avoids travel costs and inconvenience. The downside is the physical exam, and I think perhaps there's one QME I know of, Dr. Ahmad, E-M-A-D, who's out of Southern California. I've never met the man, but based on some disability, he's got an accommodation where he can do telemedicine QMEs. And I was a little skeptical about this, but the first couple I got from him were actually pretty good. I mean, I thought they were thorough reports. It's just 2 reports, so maybe it's not representative. I don't know yet. But he has a chiropractor in the exam room doing all the range of motion and physical exam and testing while he's watching. And then he interviews the patient, and then he generates a report. Ideally, I'd rather have the physician in the room with the patient. Don't get me wrong, that's the best thing. But under the circumstances, we may want to consider, in some cases, telemedicine QMEs, but I'm concerned about the physical exam. And I believe some of the QMEs have actually asked the DWC to issue an emergency amended temporary reg that they can do telemedicine. But, man, I don't know how you're going to do the straight leg raising test and the range of motion and all that stuff.
Yeah, and I think I mentioned that during the first hour, that might be an option on the table, and it was being promoted by some of the QMEs out there. But I don't know how that examination. I'm going to turn it over to Mike real quick. What are your thoughts on that, Mike, before I say anything and we return to the doctor?
Mark and I agree. I'm skeptical. I'm hesitant to recommend telemedicine. I suppose that it could evolve into useful clinical analysis of a patient, but I would be very hesitant as a defense side attorney agreeing to a telemedicine format, and then I get a report that rates out on an AMA guides, let's say at 80% or 100% or something heinously high in the absence of an actual physical exam. And there's the AMA guides are so rigid on a lot of the WPIs being based upon functionality that it would really have to be fine-tuned. I suppose it could be done. I suppose you could have some other person there, but I think most physicians, as clinicians, want to have their patients there. They want to be able to evaluate the whole patient at one time. So right now, I conceptually see this, but I'm not ready to jump on board to start going down that road. We're just not there.
Doctor, what do you think? What are your thoughts?
Well, I don't see any way that a neuromusculoskeletal examination could be performed by telemedicine. at all. Believe me, I thought about this years ago. But having a doctor in the room is a chiropractor or whatever is not the same as being there yourself. There's nothing, even in this age of sophisticated MRIs and electrodiagnostic studies, there's no substitute for a careful neurologic examination. I just got finished this morning doing a supplemental report on a patient I had seen a year ago, and they sent me the psychiatrist report. Well, this woman walked into the office holding on to the walls for dear life, supported by 3 family members, with a marked complaint of dizziness and inability to walk. All of this arising out of a relatively trivial head injury a year and a half earlier. Well, it was only by performing a sophisticated and careful neurologic examination that I was able to conclude that her problem was not neurological. It was what I called pseudo-neurological. It's not just about taking objective measurements. It's about doing all of the cross tests, validity tests, and other aspects of the examination that an experienced clinician recognizes, that led me to disagree with the treating physicians and to offer up a diagnosis of a pseudo-neurologic disorder. Now, where did the case go from there? Well, I thought it was fundamentally psychiatric. The patient did not strike me as a malingerer. I thought it was probably some unconscious process going on. But that said, I'm not a mental health practitioner, so I recommended an AME in the field of psychiatry. The patient got to a very well-respected clinician who indeed diagnosed a serious psychiatric disorder known as a conversion disorder. The point of all this is there's no substitute for performing a hands-on examination, whether it's to find the support of objective findings or whether it's to look for aspects of the case that may lead in another direction.
So I take that you believe that that's not probably an option, at least.
I don't see how it is.
I wanted to make sure, and I agree. Mike, go ahead.
I just wanted to also add that we have the provisions of the Labor Code actually give us guidance that that the physician is tasked a certain, and it's termed face-to-face time. Now, implicitly, I think everybody's always thought that this means person-to-person time in the same room environment. We would have to be shifting that diagnosis to a pure screen-to-screen FaceTime. I just don't see the medical community, with their clinical training, all they've been trained to be with patients, to say that is a substitute for, like the doctor said, a substitute for an actual examination of the patient.
Doctor, could we get you to explain to us what we should consider when selecting a specialty? And what I'm talking about is neuropsychology and orthopedic surgery. What kind of advice would you give us?
Well, that's a pretty broad question, Mr. Montalvo.
Well, we only have half an hour left.
Plenty of time.
I would say that it depends on, of course, on the type of injury that we're dealing with. Let's look, for example, at head injury. It's pretty common for individuals who have sustained head trauma to experience and report a variety of subjective complaints. Those may be physical, in terms of headache, dizziness, blurred vision, commonly. And they may also be what I would refer to as neuropsychiatric. And I don't just mean anxiety or depression. Both of those can, of course, occur, but problems with thinking, with mentation, with attention span, with cognition, with the ability to multitask and so forth. So I have found through the years that most cases of significant head trauma with symptoms that persist for several months require, at the very least, 2 evaluations. They require an evaluation by a neurologist to address the physical aspects of the injury. I won't go beyond that. I will recommend then a neuropsychology evaluation to address what I have referred to as the neuropsychiatric aspects of the case. In the old days, you would find many neurologists would take on all aspects of the case and lump it together as a post-traumatic head syndrome. Well, and you may remember that classification from the 1999 schedule. Well, we don't have post-traumatic head syndrome anymore. We've divided the patient up into the physical and non-physical aspects. So I think it's hard to get away from at least 2 evaluations. Do you need more? In some cases, perhaps. Do you need a psychiatry evaluation in addition to a neuropsychology evaluation? Sometimes, rarely. But then that depends on the nature of the patient's response to injury. If it's a profound one, such as the example I gave before, that's resulted in a serious disorder, such as a conversion reaction, or perhaps a major depressive disorder, something of that, you might need a psychiatrist. It depends on how comfortable the neuropsychologist will be with all of that. Some will address those issues, others will not. So do you need other physical examination specialists? Again, possibly. It depends on the nature of the complaint. If there are a lot of visual complaints, then perhaps an ophthalmologist is needed. If there are problems with hearing loss, ringing in the ears, then perhaps an ENT or otolaryngologist is needed. It's not uncommon in my experience to see patients with very serious and significant head injuries requiring a multiplicity of evaluations. One tries, of course, to keep that to a minimum so as to move the case along. And it depends on the specifics of the injury. So I would say to you that with head injury cases, the best place to start is with the neurologist, and then go from there with whatever referrals are deemed necessary.
Let me ask Mark.
Could I ask a question? Go ahead, Rick.
Well, I had a question for you, Mark, because we know that we're not able to get a PQME in the field of neuropsychology. It's no longer a specialty. How are you handling that situation where you have a closed head and you have an AME like Dr. Newton who's saying, listen, we need a neuropsych eval? How are you handling that? Are you going to the board, or are you entering into an agreement, or are you relying on Dr. Newton? I guess those are the 3 options.
It depends on the case. If I have fairly sophisticated defense counsel, I can usually get an agreement to do that. It's just, we obviously need a neuropsych. Let's get it done instead of screwing around and wasting time. Other times you can't get folks to agree, and so I will ask the orthopedic or neurologic evaluator that we have from the panel if they can evaluate cognition, memory, I'll just go down the list, or if they think we need a neuropsych eval. And any of them that are honest will say you need a neuropsych eval. And then I try to get the defendants to agree, and if they won't, then I'll petition the board and get an order, which seems to work, but it causes a lot of delay and actually some extra expense for the defense. So I'm not sure why people fight that sometimes.
I don't.
But that's how I get there.
Yeah, I
mean,
well,
you would, in an appropriate case, you would probably recommend a neuropsych, but I mean, there's some people who don't. So,
Well, I think.
And the other thing I was going to mention, I'm chair of the CAR Regulations Committee. We're filing a petition with the administration requesting that they restore the neuropsych specialty, and I hope any of you who have any influence with the administration would encourage them to do that. It's silly not to have a neuropsych specialty.
I agree, and I'll pin that letter. Mike wants to add
And
something.
while we're on the topic of this neuropsychology matter, I'd like to ask Dr. Neuter, because he might be able to explain what in the wide world of sports happened when it was determined that neuropsychologists, who seem to be, this is not junk science, it's a viable specialty, they were systematically wiped out of the QME situation, which really, this really is a problem when it arises. Do you have an explanation that's rational about what happened?
Well, Doctor, you don't have to answer that. I'll just say, I'll answer with one word, bureaucrats. But if you have more to add to that, that'll be fine.
Well, I won't mince words. It was clearly absurd.
Yes.
And the fact that the powers that be decided to eliminate neuropsychology as a QME specialty did not mean that neuropsychological problems suddenly disappeared.
Yeah, exactly.
We've all just struggled to work around that. One avenue that's proven fruitful is for the neuromusculoskeletal specialist to simply recommend a consultation in the field of neuropsychology, and that often results in a neuropsychologist producing what would otherwise be considered a rateable report that can then be, quote, adopted by the referring clinician. I've chosen to be more blunt about it, and I simply indicate that their case cannot and should not be resolved without a neuropsychologist, and preferably of an AME orientation, because that's where I'm coming from. I will tell you that we have 3 neuropsychologists at Newton Medical Group, and none of them became less busy after their specialty was removed from the system. So the parties have found a way to get to the consultation or evaluation that's necessary. It's just a shame that there are all these unnecessary hurdles and obstacles.
Doctor, could you, the next question I have is just to ask you to give us a brief overview of some of the common diagnostic studies that you rely on during your evaluation and report preparation. Just the audience, let me say this. Every time I take a deposition, I start out by informing the doctor that I wish to further my education in medicine. And I ask questions, medical questions, so that I can learn something. So could you just tell us what you look for and what the studies are and how they're used, just briefly?
Well, sure. I would say this might surprise you, but probably one of the most important diagnostic studies, if you want to use that word, is the clinical neurologic examination itself. I cannot emphasize that enough, and that's why I am so negative in my view on the use of telemedicine for QME evaluation. The neurologic examination provides a wealth of data if it's performed correctly. And of course, there's a need for other diagnostic tests. One of the most common that neurologists perform, along with physiatrists, physical medicine specialists, is electrodiagnostic testing. Neurologists will frequently do electromyography and nerve conduction studies. It's important to recognize that those studies are ancillary and supportive. I'm sure you and your colleagues have frequently seen a patient wind up getting unnecessary treatment based on the results of a diagnostic study. For example, let's say I see a patient with a neck injury and with a pain that runs from the neck, down the arm, into the hand. And this looks like a cervical disc problem with radiculopathy. The nerve root is being affected within the spinal canal in the cervical region. So in order to objectify the diagnosis, and especially in the day and age of the AMA guides, an EMG NCV study will be performed. Now, that study is being undertaken, and the patient is being subjected to it to try and objectively support the notion of a cervical problem. Well, lo and behold, the study comes up and reports that the patient has carpal tunnel syndrome. And the next thing you know, the patient is being sent for a decompression of the carpal tunnel. What that represents is an example of treating a diagnostic test and not treating the patient. The patient clearly didn't present with the typical symptoms of carpal tunnel syndrome, which are to be distinguished from a neck injury, but that was the result of the diagnostic study. Why? Well, because they may have had subclinical carpal tunnel syndrome, frequent in the occupational world. But I point that out simply to emphasize that there are important diagnostic studies, but they always need to be correlated with the clinical history and, most importantly, with the clinical neurologic examination. The same is true for imaging studies. This is the age of CT, well, we're well past the age of CT scanning. This is the age of sophisticated MRI studies. Once again, the goal is to carefully correlate the findings on the study with the findings on the examination and the subjectives that are being presented by the patient. We know now, for example, that if you take 100 normal 30 to 40-year-olds off the street and subject them to an MRI, about 25% of them will have a herniated disc. So that's an important statistic to keep in mind when surgeries are being recommended, for example, on the basis of the findings of a diagnostic study.
Okay, that's probably a pretty good transition to the last area that I want to touch on, and I know Mark wants to discuss both of these topics, and that has to do with the case Halkitis versus WCAB. We've had some discussion. I touched on it when I did my case law update, and of course the top cases of the past decade. That panel, just an exceptional panel. They went through Halkitis as well, both Ellen and Joe on that. Mark, why don't you just give us your, maybe you could just give us your thoughts on Halkitis, how it applies, and what the applicant's position is on Halkitis. Maybe you could start with just a thumbnail overview. We've discussed it 3 times, but start us off and tell us what your thoughts are on that.
Okay, let me give you the Reader's Digest condensed version on that, because it sounds like it's been come up already today.
It has.
Hakita, for those of you who don't recall, had a very bad reaction to surgery. There was an orthopedic injury, there was surgery, and Hakita developed CRPS, chronic regional pain syndrome. The CRPS itself caused total disability. The orthopedic injury, there was legitimate apportionment of the orthopedic condition, but the argument was, do we apportion the CRPS? Defendants arguing it would be apportioned in the same percentage as the ortho injury. Applicant arguing no, that was a result of medical treatment. That wasn't, you can't apportion to a prior degenerative condition for that. That's all due to the injury. That's not apportionable. And long story short, the Second District Court of Appeal agreed with the applicant and said no apportionment. I believe the Supreme Court denied review. That's Hakita, which, of course, I'm an applicant attorney. I think that's a correct statement of the law. There's a lot of interesting questions about how that's going to be applied down the road. And one example of the types of questions that will come up is the Justice case, which is currently pending now in the 6th District in San Jose. Justice had I believe it was a total knee replacement. And the argument was that the rating was based on the knee replacement, and therefore the rating was not, there was no pre-existing pathology left in the knee. The rating was entirely based on the artificial knee, and therefore there should be no apportionment. It was medical. That's what the trial judge decided. That's what and the board denied recon. Defendants filed a petition for writ, which was granted. And I think, to briefly summarize, they made 2 points, and this is oversimplifying, but 2 points. One was that this is different than Hikita. Hikita had an unexpected and tragic reaction to treatment. In Justice, the patient had a relatively typical outcome of the knee surgery. It was nothing unexpected, and therefore it was factually distinguishable, and the Hikita doctrine should not be extended to these facts. And then secondly, they just, I think, launched a full frontal assault, inviting the court to disagree with Hikita, which would then force the Supreme Court to consider it because we'd have conflicting Court of Appeal decisions. I could go on, but that's the short version.
Yeah, over the course of the past, 2 months or so, I've had a number of conversations with Mark Cartier. He's with the firm of Thomas Lighting Cartier et al., and they're out of Walnut Creek. They're actually handling the Barbara Justice versus County of Santa Clara. And our discussions have really focused on some issues involving direct causation, because I see Hikita's application of the doctrine of direct causation, which essentially says that an employer defendant is only liable for that portion of the whole person impairment and or resulting disability which is directly causally and exclusively related. You have a problem where you have medical treatment that causes a new condition, and I think Hikita's caused a new condition. That's not the case in the Justice decision, and this is my analysis. I think that if you apply direct causation to Hikita's, and I think that's what they're struggling to do there, the law is not that just because you have an increase in disability that's attributable to the medical treatment, that there's no apportionment. No, I think the correct statement, and Mark, I'd invite your comment on this. I think the correct statement is where you have an increase in disability, and that disability is exclusively caused by the medical treatment, i.e. a new condition, different pathology, that there is no basis for apportionment. But where you have medical treatment, and here's the hypothetical that I think the defendants have to rely on, where you have medical treatment that aggravates a pre-existing non-industrial pathology or condition, you should still have valid legal apportionment. Would you agree with that or disagree with that, or how would you analyze that situation?
Well, I agree with your statement as far as the Justice case, and I think, frankly, most attorneys kind of agree with that because that was a new condition. It was caused exclusively by the medical treatment, so that kind of made sense. Frankly, Justice is a closer case. I'm not sure that just because something... Well, let me put it this way. If there was a pre-existing condition that was causing disability or would have caused disability and it's made worse by the treatment, I agree, you've got apportionment. They can argue how much, but you've got apportionment.
No.
It's a little bit different if the entire rating is based on the medical treatment itself. And, I don't know what they're going to do with the Justice case.
Well,
it's going to be very interesting.
Well, this is what I said earlier. You remember Steinkamp? You and I and Mark Marcus, and I don't know who else was on that panel, and we were discussing, it was post Escobedo, and we were discussing Steinkamp. It had just come down, and the
Right.
Argument back then was on the applicant side that Steinkamp stood for the proposition that if you remove the pathology, there's no valid basis for apportionment. And what I said to the audience on that day that caused kind of some ruffle feathers was, no, it's a how and why case. It's a substantial evidence case. The doctor failed to connect the dots. If he'd gone back and said, listen, there's some pathology that was pre-existing, that combined with an industrial event, activity, or exposure that resulted in an industrial injury, they combined together to increase the symptomatology that led to the need for the surgery, that led to the total knee replacement surgery, that led to the whole person impairment and resulting disability. If the doctor had done that, connected the dots and analyzed it, that the apportionment would have been valid, and subsequently that was in fact what happened. They discussed the fact that it was a substantial evidence case, that the doctor just failed to connect the dots and the how and why, and we had some subsequent decisions. I kind of see Hikita's as requiring the doctor to explain why it is that the current level of disability is not attributable in any part, any measure, to anything but industrial causation. And certainly I think the argument is
you just flipped the burden of proof there.
Okay, explain
No,
that.
it's not the applicant's burden to show that it's not due. Apportionment's an affirmative defense. It's defendant's burden to show that the disability is due to something other than the work injury. I'm sorry to interrupt, but go ahead.
Okay, no, let me explain what I said there. The burden of proof, you agree, shifts back and forth. If the defendant comes forward and says, listen, there's non-industrial pathology, and the doctor agrees with that, I think at some point the burden of proof actually shifts onto the applicant to say, no, 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 Halkitis applies. We're arguing Halkitis here, and you have to come forward and establish, I would suggest, establish that no, 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 Halkitis applies and here's why it applies. And then maybe the burden shifts back to us. You know, it's kind of a shifting burden as between the parties to apply or not apply Halkitis, and that's what I was suggesting to you. I do agree that apportionment's the defendant's burden.
Yeah.
It is the
applicant has
defendant's
the burden to show that disability was caused by the work injury, and you defendants have the burden to show that some part of it was not. So I think, okay, we're just
I would
stating the
agree.
same thing different ways.
Yeah, I absolutely agree with that. But so do you agree? I mean, there's that great line in Halkitis that suggests that it's always been the case that a disability resulting from medical care is unapportionable. And I think that that is a correct statement of the law as far as it goes. And I would say, except where that condition is aggravated by the medical treatment and it was pre-existing and non-industrial. In other words, if the pathology is aggravated by the medical treatment, or if it's part and parcel of the original injury and the resulting pre-existing pathology that led to that treatment, I think you have apportionment in that situation, yes or no, even under Halkitis? Yes.
Well, yes, but only if you get one additional item. Just that by itself isn't going to do it. I think if you read Escobedo carefully, the defendant also needs one more element, and that is you have to show how and why that pathology is causing disability today and how and why it's responsible for the asserted percent of apportionment. And I find that's often what's lacking. And of course, it helps me when it's not in the panel QME report, but AMPs are a little better about that. But I just as soon have a clear report so I can settle. But you know, the fact of the matter is, just because there's some prior pathology doesn't mean you get apportionment. I mean, take degenerative disc disease. Dr. Newton pointed out that out of the total population, you could run an MRI scan, and people off the street, probably 25% of them would have a herniated disc. Most of those people aren't symptomatic. You can say the same thing with degenerative disc disease. So some of these QMEs sue everybody with degenerative disc disease. Hey, it's a pre-existing condition. Bam, 10% apportionment. That's not going to hold up because you've got to establish not only that it's there, but that it's causing disability today and why it's responsible for 10%. A lot of times at depot, the doctors can't do that.
Repeat that because I think that bears repetition, Mark. What you just said is critical. You want to keep one eye on the pathology, but you want to keep the other eye on the resulting disability because you're apportioning that disability. What caused that disability? Say that one more time, Mark.
So what? And this is Escobedo. You've got to show the pre-existing pathology is the first step in this example, of course, but then you've got, as a defendant, you've got to show how and why that pathology is responsible for causing part of the disability we have today, and why it's responsible for the approximate percent. We don't expect exact percents, but you know, why is it 10% instead of 90%? Why is it 50% instead of 2%? What's your thinking on that, doctor? And a lot of times physicians have trouble with that part of the analysis. And if that part of the analysis is lacking, even though you've established there's a pre-existing pathology, and even though the physician has assigned a percentage apportionment to it, you haven't proved the affirmative defense yet. You got to admit a gap. How and why is it causing disability today, and how and why is it responsible for the asserted percent?
Mike's, we're hogging the microphone here. Let's have Mike
I got to jump in.
And then we'll come back to the doctor to see what his thoughts are.
This isn't the Hikita presentation, but I submit that Hikita is a very unusual fact pattern. The discovery that occurred in that case, I disagree with. Hikita was 100%. How they eliminated the apportionment, I think that's up for grabs still. But the point is, the Dr. Newton brought up that a certain population in the general public might exhibit evidence of a herniated disc. Well, the trouble is, we now have the AMA guides, and many WPIs, which translate into permanent disability. This tension between WPI and disability is defined by the AMA guides. So I would anticipate that if Dr. Newton saw a patient from a post injury back claim, but there were MRIs that were pre-existed and showed a definite evidence of a herniated disc sufficient, let's say, to make it an asymptomatic DRE2, you would have by definition permanent disability. This notion that you still have to be symptomatic is somewhat quelled by the AMA guides themselves. It's an anomaly. It's different than what we all dealt with before 2005, when we were actually dealing with factors of disability, labor disablement in the workplace. So that's my chime in on that.
What are your thoughts, Doctor? How are you handling Halkitis, and what are your thoughts on that issue?
Well, it's more of a legal issue than it is a medical issue, of course. I mean, and the whole notion of what's been called throwaway apportionment of 10% or so to pathology has been a topic of considerable conversation over the past couple of years. It's hard to. I think it's become harder and harder for doctors to simply support that. I think that one of the tests medically is that it has to be shown that the outcome in the case was worser, if you will, than it would have been in the absence of the pathology that was pre-existing. That it has to have a causal connection to what actually happened in the case.
Okay, I think we've
And
tortured.
could I just respond to something? That's a good point, and something that Mike said about the WPI. You've got a herniated disc. That's a WPI in the AMA guides. There's a problem. There's many problems with the AMA guides, but keep in mind one of them is WPI does not equal disability. Whole person impairment has nothing to do with work disability, according to Chapter 1 of the guides.
Yes, it does.
They're totally different.
Look at the schedule.
Well, the schedule creates a presumption, but we also have a statute that incorporates the guides cover
Defense
to cover,
rests.
including their instructions for use, according to the Guzman case. And their instructions for use say WPI is not disability.
Okay,
So
now,
the fact that somebody had a pre-existing WPI doesn't get you apportionment.
okay, and this is why I
You
always
have to show they had pre-existing disability or that
That's
whatever
great.
the
That's
condition
Philly.
is causing disability now.
And this is why whenever I lecture, I always say whole person impairment and/or resulting disability, because how you get there is of consequence. But you're right, you only apportion the disability. And I think that Mike's point is well made, but that's the conflict between what you're explaining to our audience and what Mike is suggesting to our audience. It's a difficult,
It's a difficult concept and a problem that runs throughout the guides.
yeah. Okay,
They're really poorly suited to evaluating disability. But anyway, that's another topic.
The last issue that I want to throw out to Mark first, and then see how everybody's going to handle it, is the kite decision, whether or not the combined value equation or an aggregation should be used and under what circumstances. Why don't you just give us your thoughts on that? We'll start with Mark.
Well, that's a great question, and interestingly, my office went and looked at the post-kite decisions and found approximately 20 reported panel decisions, nothing above that level, about adding and combining. And seems to be a trend towards allowing addition if the doctor can articulate with reasonable, good reasoning, either that there's synergy or that the disabilities do not overlap. But that's the key thing from the applicant's point of view we want to get to get there. And I think that the kite decision, I suspect that kite and its progeny will probably be long-lived. It really addresses one of the problems with the guides, which is that the entire guides reduces impairments by assuming that each subsequent injury after the first injury fails to reflect. Well, they don't give you the full value. Most people know if you have one injury or disability and then another one on top of it, it's got a multiplier effect, not a reducing effect. But the CVC and the guides are opposite of that, which doesn't make any sense at all. So I think it's an attempt to find a rational workaround for something in the guides that really makes no sense and has no basis in evidence or medicine.
Let me kind of clarify that. This is how I teach the kite decision. I see kite, and Mark, feel free to disagree with this, but I see Kite as really an outgrowth of Guzman, because Kite uses in its
Yes.
subsequent decisions, they use the same type of language, most accurate, and we see that in Guzman. So I think it's a subset of Guzman, and I think that at the beginning of today, I went through three doctrines: substantial evidence, direct causation, and burden of proof, to explain a lot of cases as they come down. Kite and the cases subsequently that I've reported on seem to turn on substantial evidence. We now know that it's up to the doctor to tell us whether or not medically he believes Kite applies, and that aggregation should apply rather than combination. Combination is a reducing formula. Aggregation is just simply addition, which is going to give you a higher dollar amount after rating multiple rating strengths. I want to point one thing out here. This Kite only applies where you have a single date of injury with multiple parts of body. Kite, the easiest way to establish Kite, and Mark, feel free to agree or disagree, is where you have different regions, injuries and disabilities to different regions of the body. And let's talk about the rationale behind Kite. The rationale is pretty obvious. A person with an injury to his left leg and right arm is probably more disabled than somebody that has just an injury with the same whole person impairment and ultimate disability, just involving the right arm, but separate parts within that right arm. And that's the theory behind Kite. But all of the cases seem to turn on whether or not the doctor is able to explain why they believe that the standard rating in the standard method chapter or table is not appropriate once rated in applying the combined value equation for a reduction, but rather is better an aggregation of the separate rating strengths for the purpose of making a permanent disability award. Now, that's my analysis, that's my conclusion. What are your thoughts, Mark? Are you generally in agreement?
Well, I agree with you. I'm in general agreement. I think Kite is absolutely an outgrowth of Guzman. I mean, there's no question. It's the same rationale.
Nice.
And it's an attempt to be more accurate. And I think it is totally a burden of proof issue. And I can't tell you how many times I get reports from doctors that say, well, I think it's more accurate to add this and that. And I'm looking at it going, great, there's no reason. That's not going to get me anywhere.
Yeah.
And you need to follow up as applicants counsel and get a depo or a supplemental report. They need to explain what, they may be right, but you got to explain why. And I think it's a substantial evidence question. I do think that you might have situations where you could add or do actually more than addition. Remember in the labor code, in the AMA guides, and I think the loss of sight of one eye is 25%. But the labor code says if you lose the sight in both eyes, it's 100, which makes sense. But that's a more than additive sort of result. Now, that's not Kite. That's just in the labor code. That's one of the presumptions. But there may be other conditions where it's even more than additive. Okay. But again, the doctor's going to have to explain why.
And we have a number of cases. We've got that Pride and Joy case. We've got, I'm trying to think real quickly, where they're discussing synergy. And that's actually a multiplier, not an aggregation. And I think that also requires a substantial medical opinion that justifies an aggregation. What is the other decision that I reported on in my book? Anyway, and a lot of people, I think, confuse, tell me, Mark, if you agree with this, confuse the principle of Kite and aggregation with the principle of synergy. And I understand that synergy could be an argument not to use the combined value, but synergy, I think, is much more than just application of the Kite, the aggregation. Would you agree with that or disagree?
No, I agree with you. And my review of the cases suggested that either a synergy rationale or a no overlap rationale, if well supported, will result in addition on the rating. But I think the term synergy is being misused a lot in the cases because they talk about synergy and then they just add them. But I think what they mean is where the two disabilities tend to create, a greater disability than the sum of the parts. But again, that would be some formula more than addition. But what's that formula?
Well, it turns
we
on
don't want to be
substantial evidence.
multiplying things and
But-
getting 120%. I mean,
Mike is about ready.
I
to
got a
get-
lot
he
to
wants
say about
Go
the
ahead,
kite
Mike.
case, but I can't say it all. We don't have enough time. I agree completely from a medical legal standpoint that multiple disabilities do exist. They probably result in a higher level of disability. Remember, we're not talking about WPI. We got to be very careful about the terminology we use. I agree that the kite case is somewhat of an outgrowth of the Guzman and the schedule and the overall disability. What bothers me about the kite case is that it is too simplistic, that to add disabilities. I agree that multiple disabilities do affect biomechanically. And we're dealing with the physical medicine standpoint. Biomechanically, an individual more than just one injury. But what bothers me are a lot of these reports where the doctor simply says kite applies and there's no analysis concerning overlap. I would submit, and I've taken many doctors' depositions on this, most physicians will agree that from a biomechanical standpoint, there are probably elements of an overlap of functional limitations when you have multiple body parts to some extent or another. And there's a long history of this going back to the Hutchinson case, Mercier case in the 1970s. So, and this gets to the core issue of overlapping factors. And Dr. Newton, I'd like to ask you, I mean, do you agree that from a biomechanical standpoint, it's fairly common to see overlapping factors of functional limitation, even with competing different body regions?
Oh, without question. And I think the key to the analysis is the issue of overlap. Is there complete overlap? Is there partial overlap? If there is no evidence whatsoever of overlap, then it seems to me that we're dealing with two completely separate phenomena. There's no reason to compact the impairment rating. If I have numbness and tingling in my hands from carpal tunnel syndrome, let's say, and I have some secondary headaches for whatever reason, it would be hard pressed for me to see where those two overlap with one another.
What if the pain? What if the pain from the medium compression caused some type of neurological pain disorder that directly caused the headache? Then would there be an overlap association?
There might well be, if that
Okay.
was the case.
Yeah. I mean, these are the kind of questions we need to ask you. And as a defense guy that goes to a lot of depositions, it's sometimes painful when we go to these depositions and you're confronted with questions that people are looking at going, well, did they actually look at the case at all before they started asking Dr. Newton these questions? It takes a little preparation to make it easier for you as the medical expert to be able to parcel out what we need to know from a medical legal standpoint.
Absolutely. Richard,
Yes.
I notice you only have a couple minutes left. Can I ask you a question?
Uh-oh. This cannot be good.
Do we have to turn off the mics?
I'd like to ask the whole panel a question, which takes us back to the beginning of this entire discussion which was regarding AMEs. And I've heard a lot of positive comments from the applicant side, from the defense side, from the moderator side, with respect to the advantages of using an AME. So I'd like to put the question back to you, if I can. Why is it that in the face of all of those comments, the use of AMEs within the system is on a marked decline? It seems to me that the insurance carriers have shied away from using AMEs, notwithstanding the cogent comments that you and your colleagues are making.
Well, let me address that, and then we're going to adjourn with this, because this is what I tell my clients, and I want everybody, I'm a math guy. I write code, and that's how my mind thinks. That's how it works. I want everybody to go back and think about their Venn diagram days. We have this universe out there, and I want to put this out to the universe, the internet universe. We have a universe out there of QMEs. And of those QMEs, what percentage would you say are liberal versus conservative? Now, everybody's going to say on the defense side that, because this is for the defendants, that it's 60 to 70%, but let's just use 60% liberal. Of that remaining 40%, what percentage are, because the 40% are moderate to conservative, what percent are competent? And everybody will agree that probably half to 2/3. Now we're down to 25% of the universe of 100% QMEs are conservative to moderate and competent. Now, the way our system works is we get a QME panel of 3 doctors. Now, if you have a 75 to 25% liberal in the high end, conservative on the low end, the question is, mathematically, how many panels must a defendant pull to have 2 doctors who are conservative and competent? Conservative and competent. It works out to about 13 panels. Now, I've gone through this over and over with my clients to explain to them why it generally is not in our best interest to go off to a PQME, and yet over and over again, they want to go to a PQME, and their analysis is pretty simplistic. You know what it is? I can get a QME quicker. Of course, that's no longer the case because they're not setting within the time and people are objecting. And if I go to an AME, we're bound by the AME. And that second is so fatally flawed because, simply put, this: you are bound to the PQME too. There's no difference. You only have one evaluating physician. The only medical legal evidence that comes in is going to be the PQME or the AME and the treating physician's report. That's it. So my philosophy is this. I have always been a proponent of using AMEs, and I expect that I'm going to get some heartache over what I just said, but I've said it over and over and over again.
Well, remember, you can use your treating physician also. So I like the idea of getting an AME, and you still have the treater. You can develop that treater to get the MMI status before the exam that, you know, with the Newton group, that might be several months out, you know, just because. And so it's not a done deal just because you went to AME that you can't do anything on your file.
And my point is, there's no different with regard to being bound if you have an AME or a PQME. They're just...
Well, the judges, I'll tell you another thing, the judges like that, AMEs.
If I can answer my own question, one of the commonest complaints I hear made against the use of AMEs is that by the insurance carriers is their belief that AMEs split the baby. I'm sure everybody has heard that. AMEs split the baby. And all I can say in response to that is that it behooves us to remember our biblical history, because the wisdom of Solomon was such that he never actually split the baby, did he?
That's true.
That is great advice.
Okay, with that, let me say this: we made it through the day, and guess what? The broadcast made it through. I honestly, inside, I'm cheering because this could have gone very poorly, and it did not. What we're going to do is we're going to take now. I know a lot of people out there are waiting for the most important part of today's presentation, and that's the drawings for all the various items that we have here to raffle off. So what we're going to do is we're going to take 5 minutes. The commercials will come up again for our sponsors, and then we're going to have the drawing at the conclusion of that. I want to thank everyone that participated, either by way of viewing it over the internet, attending over the internet, as well as my presenters. They've just all done an exceptional job, and honestly, I can't tell you how, let's just say it, relieved I am. Okay, we're going to go ahead and take a 5-minute break, and again, I thank everyone. Okay, this is what everybody, all the attendees are waiting for. It's not the discussion regarding Halkitis.
No, please no.
We have a number,
but that.
We have a number of prizes we're going to give out. The way I'm going to do this is I'm going to go from bottom to top, and I notice the first couple of gifts are pretty bottom. You'll know why in a second. If your name is drawn, we are going to memorialize that, and then I need you this next week to contact my office either via email at office@montalbalaw.com or our phone number 530-529-9860 so that we can get this to you, send it to you. Okay, the first thing we're giving, and this is the low man on the totem pole, it's just a copy of my book when it comes out, Workers' Compensation Index, a topical guide.
I have ascended to the top of the workers' compensation totem pole.
And who gets that?
The winner is Vanessa Venegas.
Vanessa, I know you're jumping up and down. You're excited as heck. Either that or you're not tuned in.
We feel the happiness.
In either case, you don't have to be present. Just get a hold of us, and we're recording that information. The next one is a little bit better.
Just getting the feel here of the names.
This-
Oh, lucky one.
This item is the 2020 Workers' Compensation Labor Code, but there's something on the back. And on the back is a $100 gift certificate to Pete's Coffee. Who gets that?
Which you can't go to because we got the lockdown.
Yeah,
but
well, eventually you'll be able to go, hopefully.
the winner is Diane Ratton.
Diane Ratton.
Drum roll, please. Yes.
We hear the screams of joy.
Yes. Kind of getting into this.
Okay, now the next one is a second copy, and everybody's sitting there going, I hope I don't win these. Keep me in the bowl. The next one is a second copy of the Work Comp Index, a topical guide. But hold it, there's something on the back.
Wait, there's more.
It's a $100 gift certificate to Starbucks when you ever get out from under the...
Cleared to go. And the winner is Martin Guzman. I feel like Santa Claus of workers' comp. Good feeling.
Okay, we're moving up to a little bit better prizes, perhaps. The next one is a $100 gift certificate to the Apple Store. $100 to the Apple Store.
100 Apple Store. Michael Patrick. Ooh.
Michael Patrick, and I know Mike is not technologically challenged, so he's probably pretty excited. The next one, oh, this is a good one. You know what? I'm not going to go to that one yet. The next one is, are you ready for this, ladies and gentlemen? This is 2 boxes, 12 each, of Titleist Pro V1 golf balls. But what's special about these golf balls? They say, so that you know which ball you're playing, when somebody asks you, they say CompCalc 2019 Plus. So they have the logo on both of those. But hold it, there's more. We also have a $150 gift certificate for food and fun at Top Golf.
And the winner is Karen Soroki.
Karen Soroki.
Come get your...
Okay. The next item is the first of a number of bottles. This is a special bottle. This is Napa Valley Cabernet put up by the Camus Vineyards. And it's a special bottle that they have a limited run on. And they've labeled it, and you can get online and read about it. They've labeled it 1858. And there's a story behind that. Who gets this bottle of?
Ooh la la. Brent Lindgren. Lindgren. If there's any dispute.
Okay, so Brent Lindgren gets the Camus 1858. The next bottle is Chapelet. This is a 2017 bottle of Napa Cabernet.
The winner is Janice Harris, Haris.
Hold it, Janice Harris.
Yeah.
Janice Harris is a
We need
sponsor.
to recount?
I'm sorry, Janice, you're not getting this. Okay, we're going to pull another one. And if Janice yells at me, just remember. Now listen, I'll give her a special plug. She is I guess she's the curator and owner, I don't know, of MedLink, and they're a sponsor of this.
I'm sure you'll be hearing from her soon. The winner is now Rima Simji.
Rima Sinji. And these bottles are going up in,
Go now.
Each bottle is better than the
where?
other.
Oh,
I don't want to say what I was going to say because it sounds pretty. Anyway, this is a
know what you were gonna say.
2015 Napa Cabernet by Adobe Road. Exceptional bottle.
The winner is Angela Harris with 2 R's. If there's any dispute.
Angela Harris.
Hey, Angela.
Okay, last year we drank some of this. This is the Bevan Cellars Ontogeny. It's a 2016 bottle. It's a Napa Cab blend.
Andrew Dadaslovich.
Okay, now hold it. Did you get that right?
I sure did, and I don't drink.
Say that name again.
Dadasovich. Looks like Dadaslovich to me.
Okay.
I can say
Tori,
Hakita, I can say that.
Tori is shaking her head yes. Okay, now this is a special bottle. This really deserves some discussion. This is a numbered bottle of a lot of 60. This is number 26. Lot of 60. It was put up by Pine Ridge Vineyards, and it's a 2015 Napa Cabernet. This is a bottle that, if I were to own it, would probably go in my collection. So I'm going to make the same option to whoever buys this or wins this bottle. I will buy this bottle back at the face value if you don't want it for my collection. So,
Well, I guess
Who
the person
wins
you're
it?
going to be talking to is Stephen Riley.
hey, Steve. Steve, give me a call. You know, we can talk,
Do we
buddy.
need to recount what happened? I don't know.
No, Stephen is an applicant attorney up in Reading that I deal with some frequency.
Better try again.
Yeah, no, that's good. Let's see what this is. Oh, this is a fun one. Okay, this is a $300 shopping spree at Nordstrom's.
I like that one. Michael, almost, Pickering.
Mike Pickering? Oh my gosh, we're really focusing on
don't choose
Reading.
them, I just pick
I don't know
'em.
what's going on here. Okay. Now, everybody wants this. Can I tell you, now we're into the Apple gifts. This is the AirPod Pro, not just the AirPod. This is the AirPod Pro. These are great. Who wins the AirPod Pros?
The winner is Susan Albee.
Okay, Susan, all your friends are going to be jealous. Okay, next we have 2 Apple Watches. Count them, 2. What's the first one?
Jillian Carney.
Jillian Carney, Apple Watch. The second Apple Watch.
It is, as we pick, Anita Wheeler.
Anita Wheeler. Anita Wheeler, Apple Watch.
Good for you. You got to watch now.
Okay, we're going to hold that back. We have a iPad Air. iPad Air. Apple iPad Air.
Apple iPad Air. Let there be no doubt.
This is an Apple iPad Air.
Lori Noriega.
Lori Noriega? Oh my gosh, look at that.
I
What are
don't
the
write them, I
odds?
just read them.
Yep. Okay.
Good for you, Lori.
The next one is, this is I don't, I'm still using a 10, ladies and gentlemen. How backwards am I? This is iPhone 11. iPhone 11.
Ooh.
Yep, this is a nice
And the winner is
piece of equipment here.
Barendar Singh.
Oh, great. Great guy.
Good.
I'm glad he won too. I mean, people, honestly, I'm not picking these out. This is all legit. Okay,
No
so
fix here.
this is Bren Singh. Great. The last item at the top of the heap is a MacBook Air. MacBook Air.
What's
So
that?
this is a pretty,
I'm not a tech guy. What's that?
oh geez, this right here is, this is what I use. This is a great
Oh,
computer.
man.
Honestly.
Wish I got in on this one.
Whoever wins it's going to love it because I love mine. That's what I use.
Okay, well, I'll tell you who's going to love it. Marietta Harrison.
Marietta Harrison, you have just won a MacBook
That's
Air.
a good day.
Okay, well, you know what? We made it through, And I honestly, I almost canceled this, as I indicated. I almost canceled this a half dozen times over the last 3 weeks. And, Mike is a former Marine, and I flew in the Navy, and between the two of us, we showed up and we got it done. And all the other, I've got to tell you, just to comment on what we've seen, every single one of the presentations I listened to. And that's how well I thought it went with the presenters. And I just want to thank everybody for attending. I want to thank everybody for the encouragement over especially the last week and a half, by way of emails, texts, and then throughout today, emails, texts, and it was really it was really helpful. Okay, so that concludes the 2020 Current Issues Workers' Compensation Conference. Thank you for attending. We're adjourned.
On behalf of the law offices of Richard L. Montalvo, we hope that you have enjoyed our presentation, and thank you for viewing our conference. Current Issues Workers' Compensation Conference is held annually on the third Friday of March each year. We look forward to seeing you later this year at our October Rating Conference, and next year again at the 2021 Current Issues Workers' Compensation Conference.